Hello and welcome again to Immigration News and Views. My name is David Nachman. I'm one of the managing attorneys at the NPZ Law Group. And today with me I have Rabindra Singh, and Robbie's been with me on other videos to discuss H-1B issues. By way of background, our office is located in northern New Jersey. We also have an office in Midtown Manhattan, and we have offices in affiliated offices in India and in Canada. So what we wanted to do is circle back around to some of the questions which actually came out of our last video, and employers were interested to know what additional obligations that they had in connection with doing the H-1B. And one of those additional obligations is that once you file the LCA, the Labor Condition Application, with the U.S. Department of Labor, which is sort of the initiation of the application process, because you have to have an approved LCA before you're able to file the H-1B. It's required under the Department of Labor regulations that you have what's called a public access file. That's right. And that public access file has a series of documents. I think there are about 5 or 6 required documents that be contained within that public access file. One is that you have to have an objective wage methodology. 2 is you have to have a subjective wage methodology. 3 is you have to have proof of the filing of the labor condition application. 4 is that you have to have an attestation that the individuals are being paid the same benefits that U.S. workers are being paid on site, and so on. And so these are documents which have to be in what's called a labor, in a public access file. We call them PAFs. It's our office's policy to prepare these public access files for our clients. And the reason why we do this is because we know that human resource managers are not going to do it themselves. So what we do is we prepare those documents, and then what we do is we send them off and we give them to the human resources managers to keep on site. So in the event, one day after the LCA is posted, if somebody comes and asks, they can show them the public access file. So that's one of the additional. Robbie, when is it that an audit might occur? I mean, what might generate an audit, for example, of an employer? Is it something that is it mandatory that an employer be audited when they do an H-1B?
No, there are 2 scenarios, possible scenarios in which an audit could happen, and the audit mostly is taken care of by the wage and our department of the Department of Labor. So the 2 possible scenarios are if there is an aggrieved employee, if the employee was not happy with what was being offered to him, he could go and complain to the Department of Labor saying that my employer did not pay me the wage that was stated on the LC. The second thing is if the wage in our division, the administrator of the wage in our division, can initiate an investigation on their own. So it could happen either ways, and it's not mandatory that the audit should happen every time.
That's right. In fact, we also know from our practice that what ends up happening is that some employers who are audited, and let's say they're audited by the Department of Labor here in the United States, that information ends up getting transmitted to the U.S. consulate abroad. So when an individual is going abroad for their H-1B visa stamp and they walk into the U.S. consulate, they may be confronted with information about potential wage obligations which have been transmitted by the U.S. Department of Labor to the U.S. Department of State at the U.S. consulate office. That's a little scary because it means that any employee, even an employee who does not have a particular wage issue, is affected by that.
That's right. Yeah, because if the employer who is going to hire or who is having an H-1B employee and this employee goes to, suppose, a U.S. consulate in Mumbai and applies for a visa, then they might refuse a visa to this guy, saying that your employer was found of violating so-and-so things. So it is very important to abide by the attestations that you are making on the LCA, whether it's a wage or whether it's the posting of the LCA at the required locations. So, and the penalties could be very severe. Like you could be disbarred from using the H-1B program, or you could end up paying civil penalties. And
That's a really good point. That I'm glad that you brought that up, because that's really the probably the issue that sends the biggest shudder down the back, down the necks of my clients, is the possibility of being debarred from using the H-1B process. And the Department of Labor uses that threat in an audit. What they'll do is they'll come in and they'll obviously do an audit, and they'll figure out whether or not the wages have been, have been properly paid. But usually what they'll do is they'll say, listen, if it's egregious enough, what we're going to do is we're going to debar the employer from using the H-1B process. And that's very dangerous for certain firms, because that strikes at the very livelihood, especially in body shops, where they're not able to take advantage of the H-1B process.
Yeah, and the biggest mistake that an employer could make is attesting that you are paying this much of salary, and you don't end up paying that salary. And the debarment is at least for 2 years. So it's at least for 2 years. And it could end up for many, many more years.
That's right. And one of the permutations, of course, on this issue, which we've encountered in Department of Labor audits, of course, is that individuals, let's say, who have been working for a particular employer, have decided that they want to go back to India, or they want to go back to their home country, or they want to take off time because they're pregnant, or so ordinary labor and employment laws do apply in the H-1B arena. And if an individual decides that they want to take time off and the employer grants the individual the time, then of course that's allowed, and they can go ahead and do that. Now, the flip side of that, though, is what I think you're going to want to get at. It's called benching. So, Robbie, maybe you can explain what benching is.
So in simple terms, the benching is if the employer is not able to provide some of the tools or some of the permits, or or there is not much available work, then you put the employee on a bench. For instance, if it's an IT company, and most of the IT companies, they take individual projects, from the end clients, and they execute the project. So if it happens that the employee who is on an H-1B visa, he delivers the project, and he's waiting for his next assignment, and while he's waiting, he is basically on a bench. And so the real important thing that I want to convey is the employer is bound to pay the employee whatever was the stated wage on the LCA to that employee while he or she is on a bench.
So if the employer doesn't have a job and sends the employee down to, let's say, the islands, and they're sitting on the beach, that employer has to pay that wage while the employee's sitting on the beach.
That's right.
Because if not, it's considered to be benching.
That's right.
Yeah. So I think we're just about running out of time. I want to thank our viewers very much for tuning in. We will be back. Robbie and I will bring you additional information, cutting-edge information about the H-1B season. Obviously, as we draw closer to H-1B season, we're going to be getting information from the USCIS about what their anticipated usage of the H-1Bs are, and what we'll do is we're going to report that information to you and post it as quickly as we possibly can, so that you guys can be guided about how you want to prepare your H-1Bs. But the bottom line is, get it started as quickly as possible. Thanks very much for being with us. Bye for now.